Hey, so today is a dispute resolution day. We have Darren Heitner, Remodel Commanders General Counsel here, and we're going to talk about dealing with homeowners, dealing with subcontractors. But first, Darren, would you let the audience know about yourself and what you specialize in?
Sure thing. Well, as
Yeah.
you can probably tell from the trees waving behind me, I am in beautiful South Florida, and in particular, Fort Lauderdale, Florida. I've been practicing law for roughly 15 years now. I've had my own practice, Heitner Legal, for 10 years. And in the 15 years that I've been practicing, I've primarily focused on civil litigation, transactional work, heavy emphasis on sports entertainment, intellectual property, everything from trademarks, copyrights, rights of publicity, etc. And then a lot of the work that I do is in arbitration. And in fact, I am an arbitrator with the American Arbitration Association. And I guess as a hobby, but on the side, I do some teaching as well.
That's awesome. Hey, silly question, but would could you teach us the difference between arbitration and mediation and going in front of a judge?
Absolutely. So arbitration is considered ADR, a form of alternative dispute resolution.
Okay.
Sometimes it's required and mandatory based on contract. And oftentimes you can look towards the end of a document and see what the governing law, jurisdiction, venue may be. And if it specifies that any disputes must be adjudicated in arbitration, and more specifically, the American Arbitration Association, JAMS, et cetera, then that is the process and the forum that you need to go through. There's a lot of advantages of arbitration. Sometimes you actually even have a former judge who serves as the arbitrator. Other times it's practitioners of law, and sometimes not even practitioners of law, but typically the parties can choose and rank who their arbitrator will be, and ultimately the forum will make that determination. Benefits of arbitration are that it's confidential, oftentimes much quicker than going through the typical judicial process, and also oftentimes cheaper than
Okay.
going through lengthy litigation. But typically, the decisions, and oftentimes it says this in the contract, are binding on the parties and that the decision is final. And courts are very reluctant to interfere with the decisions made by arbitrators.
Have there ever been an instance where a court has overruled or invalidated an arbitration decision?
Absolutely. And it's actually governed either by the Federal Arbitration Act or by the individual state arbitration laws, which very much mirror what the Federal Arbitration Act says. But the big ticket items for a court interfering and potentially vacating an arbitration award would be if the arbitrator shows bias, if the
Hmm.
arbitrator has gone well outside the scope of the dispute and essentially interjects his or her own opinion and positioning from what the actual law states. And then a
Hmm.
big one would be if there's a failure of disclosure. That's very, very important in these arbitration proceedings so that the parties know whether there may be a conflict of interest. And so typically that's where you see most of the arbitration decisions vacated, is when the proper disclosures are not made in the beginning or even throughout the arbitration process.
So it's about procedure, not necessarily interpretation.
Well, right. Again,
Okay.
when parties voluntarily decide to go through an arbitration process, the courts generally do not want to interfere
Got
with
it.
the decision-making power of the arbitrator. 99% of the time, when it's a substantive matter, the court's just going to confirm the arbitration award as opposed to vacate it.
Got it. So would is this something you would recommend contractors include in their contract mandatory arbitration?
I like it.
Okay.
I think again, the benefits that I mentioned earlier, the confidentiality component, how it's quicker and much more cost effective. And my experience in court is you don't really know what you're going to get, particularly in state court and particularly when you're in front of a jury. I think when you have federal judges who are appointed by the president, are there for life, and are very experienced and distinguished, you have a better forum than state court, but I like arbitration because you do oftentimes get people who are highly specialized in the specific field
Got
in
it.
which the dispute revolves around. So if we're talking about, let's say, a construction related dispute, more likely than not, you're going to get an arbitrator who has a real appreciation for the background,
Mhm.
the general facts, as opposed to some random judge who may have no appreciation.
That would suck. All right. So if a contractor was going to go down this road, what are some of the things or relationships or documents he needs to get in in a row or in effect before he can really take advantage of this tool to handle disputes with vendors and homeowners?
Well, primarily the biggest thing is documentation. And we run into this issue in every industry, including in the building/construction industry.
Right.
Whether it be that it's a handshake deal, which is always kind of scares me, and it's not really good for either side because it breeds ambiguity, which oftentimes breeds disputes, and what we abhor, which is the unknown. Right? We
Right.
want some certainty to the best of our ability to get certainty going into any sort of dispute resolution or some adversarial proceeding. And then one step further, just having some form contract that you've pulled off of LegalZoom or Rocket Lawyer, it's probably not going to be your best decision because, again, even if you are adjudicating a matter based on this contract and its terms, and maybe it has a boilerplate arbitration clause, it may not be written in a way that best protects you and really fits within the specific industry or the scope of services that you're going to be providing. And so
Mhm.
it's having the written agreement and then it's having real specific terms for the specific transaction itself. And I know a lot of people are reluctant to spend money on lawyers when they feel as though they don't have to. And they oftentimes feel as though for the transaction itself, there's no need. And when they go into a relationship, just like if you're going into a familial relationship, you don't go into it thinking that there's going to be a divorce. But
No.
there's a lot of business divorces, which I refer to as disputes that are handled in a court of law and arbitration. And so, from my perspective, as someone who's not emotionally attached to any of these transactions or any of these business relationships, I always look at it as what's the worst case scenario and how can I best protect my client in case something does not occur as we would hope it would.
Sure. Sure. Okay. Do you mind if I ask you a somewhat hypothetical that probably isn't?
Sure.
Yeah. So we have a colleague inside Remodel Commander, Ashley, and he asked, "What would you do, Darren, if or what would you advise him if you have a subcontractor who refuses to warranty his work and says that he should cover it under his builder's warranty?" Ashley is saying it's clearly a workmanship issue, meaning the actual tradesman, not a design flaw. And so he's wondering how would you go about handling that?
If I'm understanding the question correctly, I think it
Yeah.
raises a big red flag for me, which is that the individual or the entity that is actually tasked with completing the work does not want to take responsibility, and
Right.
in fact wants the general contractor to indemnify.
Right.
If in fact there's a problem. Is that accurate?
Yeah, that's right. That's exactly
Yeah.
it.
Well,
Like,
I mean, the first question I ask myself is why are you
right.
not are you not confident in your work product? Have you had issues before? I think that's an important question. Like, have you been sued before? What has been the result of those lawsuits? Have you been threatened with lawsuits before? Have you had to settle out?
Right.
And maybe in those circumstances, the solution is to find a better sub,
Yeah, yeah.
um, which is, I understand in this environment, not always easy,
Right.
not always the best cost effective process. But yeah, that would concern me if there's not that level of confidence in your own work product to the extent
Right.
that you're asking someone else to shield you in case something goes wrong.
Right. 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 No, and that's one thing I really like about that subcontract agreement you helped us draft with these guys, and laying out the standards of workmanship, citing the NAHB's book of standards that they publish every year. It's kind of cut and dry. It's like you did it or you didn't.
Yeah.
With these guys, I know this isn't a contract issue, but it's a terms issue. We train our colleagues to hold back at least 50% of the trade subcontract pending quality inspection and release of so instead of 10% retainage, it's basically 50%. Yeah, and when you said go find another sub, I'm like, yes, you have the money to do it. Go.
Right. Right.
Yeah. Okay. So we have another question here.
Sure.
And so JJ King out of Lancaster, PA, he's asking, Darren, what are my rights as a contractor if the homeowner has unreasonable expectations about aesthetics? For example, the concrete floor is not glass finished smooth when the spec in the specification in the contract that they signed didn't call for a glass finished smooth surface. So
This is so common. This is so common.
Right.
And this it sort of touches on something that I've mentioned before. I've used these words quite a bit already in this short conversation, which is specificity versus ambiguity.
Right.
The more specific that we can be in these contracts to specify that this is the scope of work, this is exactly what we are providing, using words like only and limited to, right? Like qualifiers to make it very clear that X, Y, and Z are what we are accomplishing, be as specific as to what X, Y, and Z is, and then qualify the fact that we're not providing anything other than X, Y, Z, unless there is some sort of, let's say, change order modification to the agreement itself. That's how you keep yourself out of trouble. How do you get yourself into trouble? Is by being broad, by being vague, which breeds ambiguity and provides openings for individuals. And look, the bottom line is we live in a super litigious society.
Right.
And so if somebody believes that they can utilize some leverage to either get a discount later on, get some money back, or get everything back altogether, the thing is they're going to find some bottom barrel plaintiff's lawyer to bring a case. And that lawyer is probably going to be on a contingency. And, we experience this all the time, particularly when we're not involved on the transaction side leading up prior to any sort of dispute. But that's the key. The key is spending just a little bit of money to make sure that the document that creates the transaction, that creates the business relationship is tight as hell.
Airtight.
So that you're not spending an exorbitant amount of money later on litigation counsel.
That's right. That's right. So in this scenario where that JJ's in, his specifications don't expressly call for glass smooth. It actually calls for a different standard. How would you advise JJ to now he's in punch list, so he's got maybe 10% of the contract left. Let's pretend I'm JJ. How would you advise me to handle that homeowner before we get the lawyers involved?
And so you may not get this response from every lawyer,
right?
But this is how I view it.
Right.
Be cooperative to start. Don't get aggressive. Don't get adversarial. Indicate, tell the other person you understand their frustration, you empathize with them without admitting any guilt, because there's no guilt to admit. And then cite to the contract, cite to the specific provision, put it in writing, because if it does escalate, these are things that you can actually use as evidence to show good faith and an effort to avoid unnecessary litigation and potentially even get your attorney's fees back as a sanction for bringing a frivolous suit. So I would, again, memorialize things in writing to the other side. Don't be an asshole for the sake of being an asshole, even though you think there's no grounds for the other person to bring up any issue whatsoever. And then point to specifically, make specific reference to the contract itself. This is, I don't like utilizing this as an opening to say, we're this, let's say a big company, we've got a lot of resources, we'll litigate this to death, we don't care, we'll hire a lawyer. Why, right? The idea is get out of this as cheaply, as quickly as possible. with the least amount of bloodshed as possible. So people like me aren't making a lot of money off of it, to be honest. A lot of lawyers are just they're looking for their payday. But again, I think the best route, at least initially, is that cooperative approach. If it doesn't work, sure, let a lawyer get involved, and maybe the lawyer even starts by being cooperative as well. There's no reason to be an asshole pre-suit. It doesn't do anyone good. It may make some people sleep well at night, particularly the lawyers, but I never view that as being some sort of benefit for my client. But I think the best thing really is citation to the agreement itself, because that is the best evidence.
Right. The actual contract. You guys are contractors. Use the contract.
Yeah. Right. Well, but that's the thing, right? What are you actually suing? So like we have a case right now that's been filed against a general contractor. And the two causes of action are breach of contract and negligence. Okay. Well, first of all, anyone who litigates should know if the claim of negligence falls within the scope of what was contracted for, the negligence claim should get kicked out. Okay, sure. You could say there was a duty to provide a certain level of service, and that but for the failure to provide that service, there's been damages, which is technical negligence as a tort. But if there's a contract, that kills the negligence claim. So now we're looking at a contractual breach of contract claim. Well, if the contract says I only have to do X, and your claim is I didn't do Y, that should be a slam dunk.
Right.
Right.
Yeah. So to put it in words for the contractors, Darren, I don't mean to dumb this down, but I just want to be really clear for everybody. What Darren's saying is, if when the homeowner is pissed that you didn't do something that was not explicitly specified in the contract, it's a dead issue. It's like, don't even worry about it. It's going to be thrown out.
Well, hold on, right? Because where do people sometimes get themselves in trouble?
Right.
When there's a contract in place, but then promises are made outside of the contract, right? So be very careful. In writing, you always want that very concise, specific contract that identifies specifically what you're providing and makes it clear you are only providing that and nothing more, absent, again, a change order or amendment, and making it clear that that would change the amount of money that needs to be provided, perhaps the timetable for completion, so on and so forth. Where people sometimes get themselves in trouble is then, there's email correspondence afterwards about doing this, that, or the other.
Yeah.
And promises made, promises relied upon, and I'm using key terms, to their detriment. And that's where they can claim something like promissory estoppel. Outside of the contract, there was a promise made that they relied upon to their detriment. So just, be careful that you're not promising anything even outside the scope of that very tight contract.
Okay. Is there any language they can include in their contract that explicitly states that any conversations outside of the contract are inferior to or superseded by the contract?
Instead, yes and no. So what's typical, and this is what we call as boilerplate language, which is typically at the tail end of the contract. But one of the provisions that we like to include typically is a modifications clause, that there can't be a modification to the contract unless it's in writing and signed by the parties. This way, you avoid issues where the other side can claim there was an oral modification to the contract. However, to the extent that whatever is maybe promised by the parties, as I've just talked about, could be categorized as falling outside the scope of the contract, that's where, again, you can get into some issues. But I still like that provision, because if it can be claimed that what's attempted is an oral modification to the written agreement, that should exclude it and should be an easy motion to dismiss.
Got it. Okay. It's fascinating. Your world. There's
Not
always
so much for me, but
no. Well, there's always a stipulation. There's always a clause. There's always an out, but you have to foresee it and have it written first.
well, that's the thing, right? It's like there always is if
Right.
it's in your agreement. And that's where people get themselves in trouble sometimes. I'll have people come to me thinking something is stated in their agreement when it's not there. And they're like, oh man, I thought it was there or it should have been there. How could have I missed it? Is there any way out? Well, if no one held a gun to your head, you weren't under duress, you weren't coerced into signing the agreement, and perhaps even you had a lawyer draft it or not, you're bound by the terms of the contract unless it's illusory or unconscionable. And in most cases, it's not. I mean, it's an arm's length negotiation, and you're bound by the terms of the contract.
Yeah, you're done. Okay.
Sometimes in a good way, right? I mean, but
Yeah.
we had an instance recently. We represent a NASCAR team that did a sponsorship agreement with a mortgage company, actually, and it was a 2-year deal. And we drafted the contract, and after 10 months of the 2-year deal, the sponsors or the mortgage company just stopped paying, and this was like a perfect situation for us because now we're asked to litigate it on a contract that we drafted. And it ended up being
ideal.
a slam dunk. Yeah, right. Yeah. So not all, typically not the case, right? 99% of the time when I'm litigating, it's a client that comes to me and I didn't draft the contract. But those rare occasions, I'm like, oh yes, got the clauses I need. So
Love it. What
yeah.
is maybe this is a silly question, but what is the most bizarre or obscene homeowner or general contractor dispute that you've handled in recent past that could have been handled if number one, the contractor was careful not to verbally modify any agreements, and that he held to your standard of airtight specifications.
Well, I had a case for one of the best baseball players of all time, Manny Ramirez, who had he was building a pool that was probably bigger than most resort pools that you've ever seen before. And initially had a contract that just was going back to what we were talking about before. It was short, but I wouldn't call it concise. It was so like super broad and vague and created a lot of conflict. And when there was mishap after mishap and leak after leak and tiles falling and this, that, the other, because it didn't start off strong in the beginning, we kind of had to make up ground throughout. This is something that went on for years until we finally resolved it. But and we even initiated litigation. There were liens placed. I mean, it got ugly. Like everyone's hands got really dirty. Eventually, it got resolved to the point where he got the pool that he wanted and that arguably he contracted for initially, but not until he spent, and I'm sure the other side spent tens and tens of thousands of dollars, and probably cost almost as much as the pool. Although
how much
pools
was
are
this
very
pool?
expensive these days. I don't remember exactly. I mean, we contracted for it years ago. So, and pool, anyone who, I'm sure you all know, I mean, the price of pools in particular in this business have become astronomical in the past 5-10 years.
So Manny paid for that pool twice because
essentially, yeah. And one thing I guess I should point out that hasn't been pointed out yet as a tool of leverage, but can be used on both sides as leverage is, and not all contracts have this, is a prevailing parties clause. So a provision that says if there is a dispute, if it does get adjudicated, and there is a judgment, then whomever is deemed to be the winner, the prevailing party, has his or her attorney's fees paid for by the losing side. It does require the adjudicator of fact to decide that one side is the winner and one side is the loser. And that's not always the case. Sometimes it's sort of like a split decision. But it does oftentimes pull people off the deep end so that they realize, if I'm litigating, I'm not only necessarily paying my own legal fees, I could potentially be paying the other side's legal fees. So it's a tool that we try to, discuss with our clients on the transactional side to determine whether or not that's something that interests them.
I remember you asked me, Lane, are we negotiating or are we going to war? Because this could get expensive.
Well, and not all clients have an appreciation for just how expensive and emotionally draining and long litigation can be. And on the other hand, also, not all lawyers really do a good job of explaining that to their clients. And yeah, I mean, litigation, it can be quick, it can be very cheap. It could also end up costing six figures quite easily. So, and oftentimes I'm asked, okay, well, can you predict it? Can you peg it? No. I mean, transactional, yes. And oftentimes I can do it on a flat fee basis. On litigation, there's so many different factors that play into the situation that it's impossible.
Right. From a contractor's perspective, I mean, a couple things you've taught me is thinking about the likelihood of winning, obviously, and then the likelihood of collecting. What can you think of to give these guys maybe a broad rule of thumb for how much money is worth going to war over versus like, hey, let's negotiate and cooperate?
Well, for one, the calculation differs depending on whether you have that prevailing parties clause in your contract or not, right? Because you have more incentive to bring a case if you're confident of your position on the merits, if you have that clause in place.
Sure.
Even if we're talking about a smaller sum of money that's at issue. Then no matter what, there's three elements that we always want to look at.
Sure.
One, the merits of the case, which I just mentioned.
Right.
Two, even if you have a slam dunk on liability, what are the realistic damages, your form of relief?
Right.
And then three, a word that you just brought up is collectability, because even if you have a slam dunk case on the merits, a really good case on the amount of damages, can you ultimately collect from the other side? Assuming you have all three in place, really, I think it comes down to looking at how much you believe it's going to cost to have legal counsel involved. Right. Almost always, it's worth it to at least engage counsel. If you can't resolve it on your own, to at least engage counsel to maybe fire off a demand letter and engage in some back and forth with the other side. I would suspect that the amount of damages are going to be in excess of that amount of money. I mean, if we're talking about a few $100s, then forget it, right? Yeah. That's new. In fact, what I'll say is, and I don't know if this is still true, but at least as long as I've been practicing, as lawyers, we always deem anything $5,000 or below as nuisance value. That's actually the terminology we use in our profession, believe it or not. Yeah, $5,000 is nuisance. And, after the past 4 years with inflation, maybe that's now $7,500. I don't know, right. But we still use $5,000 really as a benchmark for nuisance value. So I think you probably have to have an amount of controversy of more than that to even consider going the next step. Because even for litigation, for me, knowing that I'm going to have to file a lawsuit, go through the process of getting a summons, process server to serve the other side, probably engage in some discovery, I rarely will take on a plaintiff if I'm doing it on an hourly rate for, let's say, definitely not less than 10 hours up front and rarely less than 15 hours up front. So, yeah, I mean, it has to be more than nuisance value to make sense.
Right. Okay. So, guys, if the sum of money is below 7,500, just argue, leave the lawyers out of it.
Well, and again, I'm not saying at $7,500, I would still say
fire off a demand letter.
Hire a lawyer for a demand letter and some follow-up. Right. Because it's not effective 100% of the time. I'll promise you that.
Sure.
But gosh, I mean, I've had so many circumstances where it took a demand letter and some follow-up and we got a resolution. And in fact, I mean, without naming defendant names, in the past 2 years, I've had 5 to 10 circumstances where I was pre-suit. So I was only doing a demand letter and some back and forth. And we've resolved for anywhere between $100,000 and $750,000, including 2 times for $600,000 just on letters.
Wow. How much?
Letters and back and forth.
Oh, yeah. Wow.
But I never even filed the lawsuit.
Right.
And we got 2 different companies to pay my clients each $600,000 without a lawsuit.
It's fascinating.
Yeah.
Yeah.
So, and I can't say that my client wouldn't have gotten that without my involvement.
Sure. Not likely.
But speculating, I really
Right.
don't think that they would have.
No, there's no leverage if you're not represented. That's interesting. Darren, what advice would you give these guys for because I know you're out of Florida, you practice primarily in Florida, is that right?
Well, I'm interestingly, I'm licensed in Florida, New York,
Right.
and DC state bars, and then federally in all the Texas federal courts and all the Florida federal courts, Northern District of Illinois, New Mexico, all the New York federal courts. So, but then I also do what's called pro hoc vice. So if I'm not licensed in a particular state, I'll waive in for the specific case. But
Right.
yeah, I mean,
Or get a sponsor.
but the practice is really worldwide. Yeah.
Yeah. Okay. What advice would you give these contractors for evaluating and setting up a relationship with with legal counsel?
It's got to be a good fit first and foremost. I mean, you have to feel comfortable with whomever it is that you're going to essentially get into a business relationship with. I think it's no different. I mean, we're service providers. You don't hire the firm name, hire the person.
Right.
And for me, like the biggest reason that I started up my own firm 10 years ago after working at 2 different firms, the biggest reason was communication. I found that lawyers tend to be terrible communicators, which was always quite odd to me, given the fact that it sort of feels like that should be our number one quality.
Yeah. I think you live on email.
So
because your response time is usually like 90 seconds after I fire something off to you.
I found it funny earlier today though. I guess it's a blessing and a curse. Now when like you type in lawyer for like Fort Lauderdale, I guess I come up first. So, like I get nonstop emails. And it was funny earlier today. I got an email from someone and I was in the pool with my kid. He was at swimming lessons. I didn't respond within like 30, 45 minutes. And the guy's like, I'm going to give you a 1-star rating because you didn't respond. I'm like, what? He didn't, thank God.
Okay.
But it's just like, I think people, maybe I need to tone it back a little bit because the expectations are a bit too high in terms of response time. I mean, I'm not taking my phone into the pool.
No, not
I'm
at all.
sure before long, we all will be.
So fit, communication, hire the person, not the name on the building.
Well, I mean, you can hire the name, but if you go hire the name, you don't really know what you're getting except for a huge bill. That floats your boat, but
right.
Yeah, I think with anything, it's fit, and again, for me, it's also big time on communication and being results oriented and not putting my own interests above the interests of my client. So yeah, I think that. But fit is key, and I get it, and if I'm not the right fit for somebody, I don't take it offensively because there's plenty of excellent lawyers out there. There's also a lot of really crappy lawyers out there, as there are in every profession.
During the interview process, what can you think of, or maybe share with us a couple tips for how to discern very quickly if we're dealing with a stud or a turd?
Authenticity for me. I mean,
right.
We're doing this on a Saturday, but honestly, if we were doing this on a Tuesday at 2 p.m. and I didn't have to appear in court, you'd be seeing me in a t-shirt and an American flag hat, probably, right? So you see what you get with me. I'm not wasting time on commuting or dressing up for anybody. But I don't think that in any way associates my record. It's not associated with my record, my level of success, or how I'm going to fight for you. So authenticity, I think, is super huge. I think you can tell that pretty quickly if somebody is trying to put on a show or is just being real with you. It's like because I interview my clients too, and when I'm taking on a client, I oftentimes, I always want to set the expectations properly. And then I oftentimes tell them when they ask me, like, do we have a strong case? Do we have a strong position? I'm like, I can only tell you based on what you know. And so I need you to be real with me and tell me
Right.
all the good things, but also all the bad things. And I think, the same should be true with respect to your interviewing of a lawyer. Like, give me the kitchen sink. Like, who are you? Like, what are you all about?
Yeah. Yeah. Are you a contracts guy or are you a personal injury guy? Like, yeah.
Right. Well, yeah. I can't tell. I like lick my chops when I've got, let's say, litigation for a contractor dispute, and on the other side is an ambulance chaser. Like,
Right.
okay,
Yeah.
like
Or a dude that
you're
does,
already you're going in with a huge disadvantage, but you
right.
know,
It's like this guy's not a litigator and he does DUI cases.
yeah.
That's funny. So for the guys listening on the recording that need representation or how can they get a hold of you?
Email, as you mentioned, is always
Right.
best. Darren at heitnerlegal.com.
Okay.
And from there,
Put that in the
as
note.
you also know, I
Yeah.
mean, once retained, my clients abuse my text messaging.
Yeah.
Um,
Sorry.
but I'm used to it. It's okay. It's okay.
Guilty.
But yeah, no, I at least I do like initial communications over email, primarily so that like I also have a record of what we've spoken of, and I'm not
Right.
confusing anything. And because those early conversations are super important, and I don't want to get to the point where we're months down the line and the client's like, "Don't you remember on the first call I said X, Y, Z?" And I'm like, "No."
Oh, I don't.
So I do like, and even email more than text, because with text sometimes it's not the best for documentation.
Oh.
Email for me it's the best.
Okay, so Darren at Heitner Legal. I'll include that in the notes here for the fellas. Beyond that, for everybody else listening, if you want to get a hold of the Remodel Commander contracts that we use for design and for build, you'll find the link below. Those were those have been massaged, I should say, by Darren. So if you get that contract package and reach out to Darren, just know that you're dealing with the guy that was the author. But anyway, Darren, I appreciate you coming in on a Saturday to talk contracts with us.
You got it.
Yeah, man. So we'll see you soon.